Welcome to the webinar today, letting some folks in from the waiting room now. Give us just a few moments. Hi, everyone. Today, our webinar is about relocation with children, and I am going to be joined here by Michelle Dellino with Dellino Family Law Group to deliver some information about this topic. First, I'm just going to introduce myself. My name is Melissa Rosenberg, and I am a therapist here in Seattle who works with clients who are dealing with all aspects of the divorce and separation process. I work with clients in the early stage of things when they're trying to determine their best path forward and whether or not relationship repair is possible or how to navigate moving forward with separation. I work with clients who are in the middle of their emotionally complex family law situation to get through it and have adequate emotional support. And I work with clients on the other end who are trying to rebuild their next path forward. I also work with couples, and I really enjoy trying to support people along their process here. Today, I'm here, though, as a moderator for this webinar with Dellino Family Law Group, and Michelle Dellino is going to be answering your questions and delivering information about relocation with children. So the way it'll work is she's going to deliver information, but please go ahead and submit questions if you have them. You can do it in one of two ways. There's a Q&A at the bottom of your Zoom screen. You can submit a question there. It will show your name unless you mark yourself in as anonymous attendee. You can also put it in the chat, and I'm going to set up the chat so that you can just only chat with me. So if you want to submit a question that no one else sees at all, you can submit that directly to me via the chat. And I will pitch these questions to Michelle. We'll try to get as much answered as we can today and hopefully leave you feeling like you got some good information from this webinar. All right, so I'll turn it over to Michelle.
Hi, thanks for being here. I'm Michelle Dellino. I am the owner and founding attorney of Dellino Family Law Group. We have two offices in Seattle, an office in Bellevue, and we help clients literally all over Washington State. So we do a lot of work in King, Pierce, Snohomish, Thurston counties, but we also appear in as far away as Spokane, Chelan, Whatcom County, Clark County, you name it, we've probably been there. So anyway, our normal in family law is probably you're crazy. So if there is a situation that you are dealing with, we've probably dealt with it before and we can get you through it. Today, we're talking about a very specific topic. We are talking about relocation with children. So before I get into that, I'm just going to go over a few more basics. I am an attorney, but I'm not your attorney unless you and I have an attorney-client relationship. And somebody on the webinar, maybe we do. I don't know. But if you're here to get information, that's great. But nothing that I should be giving you should be taken as legal advice. If you want legal advice, you need to actually have an attorney-client relationship with me or any other attorney to get personalized information that's confidential about your situation. So if you ask questions today, like Melissa mentioned, great, please do. I like to answer questions. I like to talk too, but I like to answer your questions and get you some value. So I'm going to be going through information and I'll stop at different points to see if there are questions that have been put to Melissa for me to answer. But if you ask something that's really fact specific, that's like a hypothetical, I might not be able to answer it today. That's kind of not the purpose of this. This is more about general information than anything. So again, this is not legal advice, it's general information, but hopefully you will find it helpful. I've been practicing complex family law for over 15 years. So like I said, I've probably seen pretty much every situation that you could encounter. Our firm has 14 family law attorneys and a full support team. So if you need assistance, we're here to help you. If you're trying to navigate this on your own, I wish you luck. And I highly recommend that you at least schedule a consultation with an attorney. It doesn't need to be at our firm, but somewhere, especially if you're contemplating relocation or if you've been served with a notice of intent to relocate by another parent. There's two sides of this issue. So with that said, we're talking about this today because I think relocation with children really doesn't get enough attention. It's in every single parenting plan. And I'm going to tell you a little anecdotal story before I start the content about this. Almost every time I finalize a parenting plan, which has been probably thousands of times now, almost every time, one of the sides is like, oh, I want to change this big paragraph that's in the parenting plan. Every parenting plan has mandatory language that gives you Washington's Relocation Act. And what does that mean? It's language that talks about what if a parent wants to move and things that you have to do and notice that needs to be given. And it's in every single parenting plan, temporary plan and final plan. And somebody always wants to change the language. And I get why, because you're like, wait a second, I don't want to give that much notice. I want, whatever. And that can be really confusing. And any attorney is going to tell you, You can't change the language. It's mandatory. It's statutory, which means Washington came up with this act and it has to be in there so you know about it, but you can't change it. So a lot of the time what happens is when you're finalizing your parenting plan, you skip over it and you're like, oh yeah, maybe we'll deal with it later. Totally normal because you don't need to deal with it in the immediate, but it doesn't get enough attention. And then later somebody wants to move and they're kind of wondering, well, what the heck does that mean? How do I do that? And so that's what we're going to talk about today. We're also going to touch on if you're the other parent and you got to notice that your child's other parent is going to move, what do you do? Like, can you do anything about it at all? What are your options? So we're going to talk about all of that. And if you have questions, like I said, feel free to let Melissa know. But simply put, the best way to put this to you is Washington's Relocation Act requires you to notify your ex, the other parent, if you intend to move with the children under certain circumstances, especially if you are the primary parent. If you're not the primary parent, you don't have to follow the Relocation Act. So we'll get into that a little bit. But basically, you have to give notice. And then if the other party doesn't object, you get to move. Though you might be forced to return if you do it wrong. So the point here is, this is why I said earlier, if you're going to do this on your own, at least talk to someone, because I have had situations where people have come and they've tried to do it on their own and they've done it wrong. And they've been ordered to come back and they've been found to be in bad faith and a bunch of things that they didn't mean to have happen. They just didn't understand how to follow the Relocation Act, which is normal. And I can tell you that even non-family law attorneys, they don't know what the Relocation Act is and it's confusing to them. So it's confusing to everybody. Let's just put it that way. And this is to have more of a real person, real language dialogue and talk with you about it. So if you're considering it or it's something on your radar, you kind of know at least the basics of how it works. So basically, you give notice, other party doesn't respond, you get to move. You give notice, other party responds, you may or may not get to move. And if the other party does respond and objects and does a formal objection, then you will either decide that through negotiation later or a court will decide. So that's kind of the basics of what will happen. So what we're going to talk about is step by step how relocation works and what your options are. So first of all is like, does this act even apply to you? You might be able to ignore it if you fall under one of the categories. If you have no parenting plan or residential schedule in place, it doesn't apply to you. So sometimes people will be like, well, we've been separated a long time. We don't have a parenting plan. We never filed for divorce, or we were never married and we're unmarried parents. Does it apply to you? No. It doesn't. It doesn't mean that moving without telling the other parent is a great idea because somebody could go get an order to bring you back. But the Relocation Act and all of these nuances don't apply to you if you do not have a parenting plan. So I like to put that out there. And usually some people will drop off the call at this point. Anyway, it doesn't apply to you if you don't have a parenting plan. If you have a temporary parenting plan, it also applies to you. You might have heard me mention earlier, even a temporary parenting plan, there's a big chunk of text in there that gives you the Relocation Act. It's required. So temporary or final plans, if you have that, this applies to you. So that's good for you to know. So the thing to note about that is if you don't have a parenting plan, it's still helpful for you to think about because you'd look bad in a court's eyes if you left and you had a highly involved parent on the other side. If you have a parent on the other side who has been absent for years and you don't have a parenting plan, probably not. But I've had situations where couples were going to separate legally or get divorced and no one had filed anything and someone left and that looked really badly, especially if the other parent had a bunch of time. So anyway, that's something for you to think about. If your parenting plan is not governed by Washington law, maybe you live in Washington now, but you have a parenting plan from another state. This doesn't apply to you. You might have, and that could totally happen. You could have moved here and had a parenting plan out of California, New Jersey, wherever, and you have not registered here and it's not governed by Washington, then you're not subject to Washington's relocation law. Your state has its own relocation law. So you need to look at your plan for that and talk to an attorney where your parenting plan is. That's one thing for you to know. Even if one parent still lives here, here's the other side of that. Let's say you move to Arizona and you're living in Arizona, but you have a Washington parenting plan. So then, yes, it does apply to you. You don't have to be living in Washington to have it apply to you. You have to have a Washington parenting plan. So I like to kind of go through that. If both parties have moved away from Washington and no one has registered the plan anywhere new, it also still applies to you. So something else for you to think about. Here's the other time, and this is really important when it doesn't apply to you. If you have a Washington parenting plan, but you have less than 45% of the residential time per year on average, including holidays, special occasions, vacations. So like, let's say you're not the primary residential parent. Maybe you're pretty close, but you're not the primary parent. If you have less than 45% of time, if you total up all your time, it doesn't apply to you. So that's another thing. You have to probably in your parenting plan, tell the other parent where you live. It's pretty common to have a provision in there that says, either party will update the other party, with addresses, or it's just kind of common sense. If you did your own parenting plan and you forgot to put that in there, you still need to tell the other parent where you live and where your kids are staying, but you don't have to follow the Relocation Act. So that's really important. The parenting plan, if you move, you have less than 45% of the time, the parenting plan will stay the same, unless somebody moves to modify it otherwise, but the Relocation Act isn't required. So that's important for you to know. If you think relocation should be a basis to change your plan and you have less than 45% of the time, you don't use the Relocation Act, you would file what's called a minor parenting plan modification if you felt the plan needed to change. And this is where I'm telling you it's very important that you understand your options. And if you're going to file for relocation and you're not sure, whether you have 45% or more or less, even if you have less, you need to talk to an attorney. Because if you don't file a minor modification and you try to change the plan, you're probably going to do it wrong. And if you filed for a major modification, your petition would get dismissed and you probably end up paying fees to the other side for doing it wrong. So be very, very careful. But 45% of the time or less, you need to go minor modification to change your plan, not Relocation Act. So that's important for you to know. So for example, well, I don't even actually think I need to give you an example. I think you get it. So here's the other time it doesn't apply. If you're moving within the same school district, when does it apply? It applies only if you're moving out of the school district. I had a relocation case years ago where one party was trying to move from Seattle up near Green Lake. So from Seattle schools over to Bellevue. Relocation, notice of relocation was required. Even though you're only moving across 520, you're moving to a different school district. I had a case once, and this is not uncommon either, where you're up in the north end and maybe you're near kind of like King-Snohomish line, and maybe you're in the North Shore School District and down the street is the Lake Washington School District. If you're going to move even a couple miles into the Lake Washington district, it is required that you give notice and you follow the act. So when you are moving school districts, it's required. So in that situation, North Shore to Lake Washington, you could move like a mile and that could apply. Or you could be in Seattle, and let's say you're living up near Shoreline in Seattle schools, but you're still in Seattle, not across 145th, and you move all the way down to like Seward Park, you're still in Seattle School District. Relocation notice is not required. So it follows school district, not distance, and that's very important for you to know. The court generally thinks, and Washington law follows the rationale, that moving within the same school district has a minimal impact on most parenting arrangements. With traffic now, especially in King County, that's not always the case. So if you're in a situation where you're like, I don't need to give notice, but I want to try to change my parenting plan, you could do that again as a minor modification or a major modification if other factors also applied. But anyway, there are other ways to change your parenting plan if you're within the same district, but in the same district, no relocation statute, you do not give this notice. There's no need to file anything with the court. Our firm recommends you send the other side a quick email, text, our family wizard, and tell them you're moving, here's your new address, that's it. So, and you want to do that in writing so you can prove that you did it, but you don't have to follow the process. If you're moving for a short period of time. So unfortunately, this is not clearly defined in the statute, but if you're moving for a short period of time and it's a temporary move, you don't have to follow the statute, especially if it's going to be during the summer and you're not going to be changing anybody's school, you're going somewhere for a month, you don't need to follow the relocation statute. That probably comes under vacation time. So that's the thing to know. I'm going to move on now to talk about advanced planning for relocation. First of all, any questions before I do that? I'll take like one or two.
There's one question here. This participant's saying that they have the kids 100% of the time with a 5-year protection order, no visitation in the parenting plan. Also part of the address confidentiality program in Washington State, and the other parent doesn't know where they live. How would this law apply in that situation?
Well, if the other parent has no time, but they are still a legal parent, meaning they haven't been substituted out for another parent to take their rights, but they're still a parent, they just have no time, then you still need to give notice, unfortunately. But you can do it with your address being protected. You could have any response served on your counsel, but you doesn't mean you have to expose your address, but you still need to give notice. And are you unlikely to prevail? No, you're probably going to be able to move. And an objection from the other side would be pretty silly if they have no residential time and a protection order. There are factors that we'll get to that the court reviews, and there would be, I can't promise you ever what will happen, but there would almost be no way that that person will be able to stop your relocation. But you still have to give notice, because if you don't and you move, and then that person says something after the fact saying, well, I didn't get notice, the court could still basically punish you for not giving notice, and it wouldn't be good. It wouldn't follow the statute. So yes, give notice, but have an attorney do it for you. So there's an address where you can receive a response. You probably won't, but you still need to do that. You need to file proof that you served it. You need to do all of the things that you need to do, but you don't have to expose your address. So anyway, I hope that helps. Anything else?
Yeah.
Yeah, one more, and then we'll move on to the planning.
Another participant's asking how to approach the relocation matter in their parenting plan if they have the kids 99% of the time and the other parent kind of treats parenting as an inconvenience and not as a duty.
How to approach the relocation. I mean, if you want to move, give notice and move. Like, I would definitely you have to give notice even if you have 99% of the time. And if the other parent is like not interested in parenting, they probably just won't respond. You could even give them a heads up and say, hey, I'm serving, here's the notice. You don't have to file a response if you don't care. I mean, you don't want, if you want to give that extra communication to them to be like you don't have to do anything because you think they're not going to read closely, you can, and then they can read it and see that you're right. You're not trying to pull one over on them. But sometimes people get served a notice and they freak out and they think it's like something bad. And you're like, hey, I have to give you this, but you don't have to respond. You might want to tell the uninvolved parent that, and that might help. So let's talk about advanced planning. Assuming that none of those exclusions apply to you and you've got to give notice, let's talk about what you can do to increase essentially your odds of winning a contested relocation and what that looks like. First thing is this. So you're going to want, if you're planning ahead, and I will have clients come to me from a strategic point of view, almost everybody that's thinking about relocating, unless it's like you just found out. So if you just found out, like, let's just say you just found out and you found out that I have to move, I have military orders and I have to move. Well, you still have to give notice, but you don't have to give a 60-day notice. So first of all, let's talk about timing, advanced planning. 60 days notice before a planned move is what is required. So you have to give 60 days notice to the other party in writing. And you have to fill out a notice of intent to relocate and serve it on them. I also will tell you that when you're thinking about that planning, the notice of intent to relocate is really important. Like, we will often spend a lot of time with clients going over what's in that notice, because that is important. It lays out your basis for relocation. If you miss things in there, I mean, you can supplement it later, but that's really not what you want to do. You want to lay out everything in there. And you really want to think about the relocation factors. So the Relocation Act, it requires 60 days notice, but in a situation I was talking about where you got military orders, you got to go, or you get something from your job that's like, hey, your job's being phased out, you have to take this job and it has to start in 2 weeks in California, we're going to pay to relocate you. Those are reasons to give 5 days notice if you have to. And the real thing about this that's important for you to know that can be complicated for people is you need to act in good faith. And if you don't act in good faith when it comes to relocation, that can really be used against you. So if you're like, hey, I gave 10 days notice and you really didn't just find out, or you really don't have to move that quickly, like, don't do that. Give the proper notice, because it's going to come back to really hurt you, is the best thing to say. Like, you really don't want to let that happen. You want to make sure that you're planning ahead and doing it the right way. Like I mentioned to you, almost any client that I have that is planning on moving does something ahead of time to think about, how is this going to look better for me? And that's normal, because relocation is a big thing and you want to be smart about it. So I'm going to talk about that here in a minute. But the basics are, you've got to give 60 days notice. That's required by the statute. And if there's unforeseen circumstances, you have to give 5 days notice as soon as you become aware. So, but the 5-day notice, don't try to do that unless it like really applies, because that's something that's going to really receive what I would call strict scrutiny from the court. And they're going to say, really want to make sure you did not have the proper time. So then once you file that notice and you're planning ahead, a lot of times people will think like, gosh, I don't know what to do. I don't know if I should get a place if I don't know if it's going to be approved. Well, you'll have an idea after talking to an attorney how likely it is. Like the person that asked the question, or the other party has a protection order and never sees the kid. Highly likely you're going to be able to move. However, if you have a pretty involved parent who sees the kid every week, that's a different situation. So anyway, you'll want to talk to an attorney about that, and you'll want to plan ahead. But the thing for you to know is after you serve that notice 60 days in advance, the other parent has 30 days to file an objection. And just like your notice of intent to relocate really needed to be detailed and lay out all of the options, their objection. So if you're the objecting parent, you just got served with this, you need to work with an attorney on your response. That response should not just say no. That response should go through and basically all of the factors and lay out strongly why it should be a no. And that's going to lay the groundwork for then what's going to come next in your case. So objection must be filed and served within 30 days. If you miss that, then, the other party can move and you can't do anything about it. So don't miss it. Like, pay attention to the deadlines. This is really, really important. If you want to look up Washington's Relocation Act, then, you should do that and kind of get familiar with it. But really, like, before you start looking up things online, it's RCW 2609520. If you're one of these people that likes to Google, RCW 2609520, I believe, is still the act. You won't know really like what the details are behind that. So you'll really want to talk to somebody. The planning, super, super, super important. So if it applies to you and you're planning, you're thinking about how's this going to look? Well, there is a factor test. There's a bunch of factors that get decided. There's actually 11 factors. One of them might not apply because it pertains to a temporary order, and we'll talk about that in a minute. But there's 11 factors, 10 for purposes of consideration. And the court is going to look at those factors and weigh them. And that's how, if the relocation is contested, that's how the court's going to decide. So that's why advanced planning is important. One thing you can do, increase your time with your kids before the relocation. So if you have a parenting plan and you're following it, and you're worried about, oh gosh, we're pretty close on time, even though I have more than 45%. If the other parent is, like somebody mentioned, not super involved and wants to give you extra time with the kids, take it. Take as much time as you can, because then when you're going to seek a contested relocation, it will be a situation where you can say, hey, yeah, I have this much time on paper, but over the last 6 months, I've also had like 30 additional days because the other parent has been traveling for work or didn't want to take the time or gave me an extra month in the summer, things like that. So it's important that you increase your time if the opportunity is there. Here's the other thing to know. If you are the primary parent and have more than 45% of the time, there is what we call a presumption. This is very important. There is a presumption that you should be allowed to relocate with your child if you have him or her at least 55% of the time in your parenting plan. The opposition can attempt to rebut the presumption, but it's an uphill battle for them, to say the least. So especially if you are a parent and the other parent is like what I would call an every other weekend parent, it's going to be the presumption is strong for you. Okay. That's different than if the other parent has 40% of the time. You still have the presumption. That don't get me wrong, but you're in a situation where maybe the other factors are going to matter even more. But anyway, you have a presumption that if you are the primary parent, you get to move. So strengthening the factors and thinking about that is extremely, extremely important. So, Melissa, any other questions before I keep going?
Yeah, somebody's asking, what if you're not sure where you're moving to when giving the 60 days notice? Like if you have a lease, you might not know where you're moving until the final 30 days before the lease expires.
Yeah, and that's why drafting that notice of intent to relocate, which I'm going to talk about next, is really, really important. You are going to need to specify as much as you can, like the school district, where you're moving, all of that. If you don't have the address because you haven't signed a lease yet and you don't know what unit you're going to be in or what building or whatever, you can say TBD on the exact location, but you're going to want to give some details, and you're going to want to give information at least about the general area, and then there's other things like if you have a job there, what your ties to the area are. There's those kinds of things that are important in the notice. You don't have to give the exact address. You'll just have to say you'll supplement it as soon as it becomes available. So there's ways around that. So when we think about drafting and serving the notice, and I want to make sure you understand this. You're going to draft and serve a notice as well as a new proposed parenting plan, because relocation is to change the parenting plan. You have to, right? It's basically a modification of the parenting plan for reasons of relocation. So at least 60 days prior to your intended relocation, you should draft and serve the notice upon the other parent. Ideally, you should have an attorney do it, because like I said, relocation is usually highly contested because somebody doesn't want you to move unless you guys agree on it. And there's not a lot of compromise. There's not. And I've been able to negotiate compromises. I had a case once, a few years ago, I didn't think we were going to be able to resolve, because it was like moving from Washington to New Jersey. My client was wanting to move to New Jersey, and the other parent had a pretty decent amount of time, even though they weren't primary. But we were able to negotiate a really liberal long distance schedule, a lot of summertime, a lot of break time. We were able to work it out without a trial. But that often doesn't happen. A relocation often goes all the way to trial because there's no in between. You either move or you don't, right? And so drafting the notice, like I said, I cannot stress to you how important that is. So the content of the notice really lays out the basis for the relocation. You can get those forms online, but I highly recommend that you get an attorney to help you. The other thing to know is that it's generally considered bad faith to relocate for purposes of keeping the child from the other parent, or just making it difficult for the other parent and the child to be together regularly. So you need to be careful of your wording in how you word the reasons for wanting to move. It should never look like you're just trying to keep a parent away from a child, because that will be flagged by the court pretty quickly. If your intended relocation warrants a change in the parenting plan, which it usually does, not always, but it usually does, you should draft a proposed parenting plan to be served along with a notice of intent to move. So like, for example, if it was that thing where you're living in the North Shore School District and you're moving like a mile to Lake Washington, you probably don't need a new parenting plan. You're probably just giving a notice. But if you're moving from Seattle to Olympia, and all of a sudden you're hoping your child's going to be going to school in Thurston County, you're going to need a new parenting plan. Like, that's probably going to have to work, unless you have long weekends and that's still going to work, whatever, but it's probably going to change your parenting plan. So you'll need to draft a new proposed parenting plan that would reflect if you had the move, and serve it along with the notice of intent to relocate. Here's the thing about that. Drafting of that parenting plan is also super important, because you're going to want to show good faith depending on your circumstances. Like, if you have an every other weekend parent, you're not trying to cut them off from seeing the child ever. So you're going to need to make sure that you're proposing a reasonable long distance plan. Because if you don't, and it's just like, oh, now we're moving and you never see your kid, you see them 2 weeks a year, that's going to look bad for you. And it might look like you're in bad faith when you really aren't. You just didn't know what to put. So negotiating and drafting a proposed long distance parenting plan to serve with your notice of intent to relocate, super important, super important. So I mentioned earlier exceptions to the notice rule. I just want to touch on that again. Do not give less than 60 days notice unless there's no other option and you can support it. That's all I want to say about that. Serving the documents is also really important. So now you've drafted the notice, or your attorney has drafted the notice. So the time period begins, that 30 days that they have to respond begins when you actually serve the notice on another parent. This typically means having another adult other than you hand the documents directly to the parent, or mailing the documents to the other parent and requesting return receipt, like certified mail. It's unclear, this has come up numerous times, it's unclear under the law whether you can mail the documents or whether someone else must do it. And I have to tell you, I highly recommend that you actually have it served, just so there's no question that someone received it. There have been issues where it's like, oh, I served it with a return receipt, someone else picked it up, I never got it, just all kinds of things. I mean, you can do it that way. We feel the best practice is to serve the other party, unless it's an agreement and everybody's fine with things. Then you could just mail it alone, and that's a different situation if no one's going to object. But I always think it's a best practice to serve the notice and send it via mail, both ways. Then there's no question that you made every good faith to let them know. At this point, you do not have to file that with the court. At this step in the process, you don't need to file the notice of intent to move and your proposed parenting plan or proof of service. I always recommend that you do, just so there's no question about it and it's in the court file, but you don't have to. You probably will need to eventually, but regardless of whether you file them, you should save them for your records. You might need them at some point in time. So the other party has 30 days to respond. We talked about that from the time of filing and service, and you have to add additional time to your notice requirement if you only mail it. So there can be ambiguity with that too. But I highly recommend, like for example, you also have to take into consideration if there are weekend days. So anyway, long story short, have an attorney do this so you don't screw up the notice requirement, and make personal service if at all possible. So then what do you do if the other party doesn't object within 30 days? Can you go? Yes, you can, but you have to take other steps. If the other party fails to object within 30 days, you can go to the courthouse or have your attorney do it and get an ex parte order allowing you to relocate and adopting your proposed parenting plan. So that's important. They lose all ability to object to the relocation once you enter such an order. So I highly recommend that you go and get an order right away if you can, if the other person does not respond and you're worried that they're gonna try to create problems for you later. So that's really important. And there's a way to do that as well. But yes, go and get a new parenting plan and get yourself going. That's the best thing that you can do. So what if the other party doesn't necessarily object, but they still appear? So it's possible the court would require you to provide the other side with notice of your motion if the other party appeared, even if they didn't file an objection. So what that means is this. Let's say somebody has an attorney and they file a notice of appearance. So that person files a notice of appearance in the case, but when they do that, they don't file an objection. And then 30 days go by and nobody's filed an objection. Well, if somebody has appeared, whether it's a pro se party filing something, which means representing yourself, or another attorney, even if they didn't file an objection, if they just filed an appearance and they missed the deadline, you've got to give them notice if you're going to go down and try to get your relocation approved after 30 days. So a party informally appears if they do anything that indicates an intent to appear or disagree. It could be filing a parenting plan. It could be sending your attorney a letter that says, you'll have to take me to court if you want to move with our child. That's an informal appearance. Anything like that, you have to give them notice. You'd look in bad faith if you didn't. So then the other question is, can you move without court order if the other party doesn't object? It's allowable. You don't have to go get that order saying you can move and entering your parenting plan, but I recommend that you immediately get an order and do it just so there's no confusion later if you can. Hopefully that's helpful. What to do before I talk about what to do if the other party objects? Any other questions at this point you want me to answer, Melissa?
There's just one question. If the other party has 42% and you're the primary, do you just have any tips around how to strengthen your case?
Yeah, it's going to be, and we'll get to some of that. It's going to, if we have time, it's going to be a fact-specific situation. I will at least go through, depending on time, what the number of factors are, and you're going to want to get as many of those factors to weigh in your favor as possible. If the other parent has 42%, it's going to be a tough battle for you if they object. You have the presumption, so if you have good reasons, you might get to move. If your reasons are borderline and you're not presenting a compelling case and the other party objects, maybe not. It's really hard to say. But you do have the presumption, even if you have, 56%, you still have the presumption. So you want to have as strong of a case as possible. It's a great question. That's why these situations are super fact specific. I could take one more before I move on if there is one.
I don't have any other questions currently open.
Great. Okay, perfect. So what to do if the other party objects? If the other party objects within 30 days, it initiates a unique court case. Now a court case is open. They have to file their objection and they start a court case called a relocation action. Ultimately, the relocation action leads to a determination of whether to allow the relocation with the child and what the parenting plan should be if you're allowed to relocate with the child. A judge that denies your request to relocate with the child can also implement a new parenting plan if you elect to relocate without primary care of your child. This is important for you to know. Okay. Two things. Number one, if you've ever been in family court before, you might have been on what's called the family law motions calendar, where you have a court commissioner making decisions. That's like short of a trial. In a relocation, a judge will hear all of the matters. And so that is good because it cuts off another option for having a judge review a commissioner's decision. But it also means that the decision that the judges are making is probably going to be what happens in your case, even on a temporary basis. So it's important for you to know that you want to do this right. Second thing, that judge does not have authority to stop you from moving. Like, you're giving notice of intent to relocate. You can still relocate. The only thing that the court can stop you from doing is relocating with your child. So that's why I mentioned that the court might order another parenting plan. If you choose to relocate, but you decide at the end, I'm going to go anyway, even though I lost the relocation and my child's going to stay here most of the time and stay in their current school and I'm still going to go, well, then obviously a new parenting plan is also going to be required. But maybe you really have to go, you really want to go, there's really no question about it. And it's more of a situation where you're hoping that your child can go with you, but you have to go no matter what. So in that situation, a new parenting plan would still apply. So if a relocation action is opened, there's going to be 5 stages, and that might sound like a lot, but it's important. And that's why I'm telling you, like, you don't want to make mistakes in a relocation action. I actually love a relocation case because they're quicker. So like in a divorce case, you get a case schedule that's like a year out of all these things that need to happen if the case gets contested. We have what's called a accelerated case schedule in a relocation because you shouldn't have to drag it out for a year and you don't have to give a year's notice. So a relocation case schedule will have trial within a few months. That's good. Like, it means everything happens quickly. So the first thing that happens is temporary orders. We'll talk about that in a minute. The second thing that happens is your response to the objection. They object, you get to respond to that. The third thing that could happen, and the temporary orders is optional, but you might want it. The third thing that could happen is discovery. That's also optional, but it's highly recommended. Discovery is where you get to discover and ask the other party questions. You might want to take their deposition and ask them questions under oath to use. In your case, you might want to send what is called formal discovery that they have to fill out about their move. You get a chance to ask them a lot of questions and help build your case. And they can do the same to you. So then there's a discovery period. And then there's alternative dispute resolution, which is required. So that's usually mediation. You could also arbitrate instead of mediation if you want to resolve your case. But most of the time you'll go to a mediation. You'll try to see, is there any way we can work this out? And if there's not, then the last thing that'll happen is a trial. So if those things happen, that's kind of the process of the case. So if the other side goes ahead and files that objection and you want to move, the thing to think about is temporary orders. Do you need to move? Do you want to try to move temporarily before your relocation is approved? Do you need to move temporarily? Assuming the other side properly objects to your notice of intent to relocate, they are also supposed to file a motion for temporary order preventing the move with the children. The motion could basically result to restrict you from moving with the child during the relocation action, or it can result in you being allowed to temporarily relocate with a changed parenting plan. So they're supposed to do that. What ends up happening sometimes is they don't. And then you're like, can I move? Can I not move? And what I recommend that you do, and what you really should do in that situation, is that you should file your motion for a temporary parenting plan to relocate on a temporary basis. And some people are like, well, why would I do that if I might have to move back? Well, to strengthen your case, and sometimes you just need to go. So you might not have months to wait. You might need to move in 60 days. If so, you need a temporary order. And if you are moved with the kids on a temporary basis, it's highly unlikely you're going to have to come back. So you're probably going to be in a stronger position. So you could sometimes get a temporary order saying, I can go to Texas now with the kids on a temporary basis while the case progresses. And then you might mediate a couple months later after some discovery. And by then, the other parent might be like, well, the kids are already in Texas. This is going to be really hard for me to get them to have to come back. I'm going to have to show that something changed. And in that kind of a situation, you might be able to just work out a negotiated parenting plan at mediation. So there's a lot of different options, different things like that that you can do. So, but a temporary order either brought by the other party or by you sometimes will happen. And if it does, you might want to talk to an attorney about whether that's something that you want to do or need to do in your case. The next thing you need to know, if the other party files an objection, you've got to file a response to the objection. And the notice, the objection, and the response are all super important. They give a lot of information to the court that's going to be important in setting forth your case and going to trial. So if the other side properly files an objection and starts that relocation action, you're required to file and serve a response to that. So it's a very long name for a document. I think it's called Response to Objection about Moving with Children and Petition about Changing a Parenting or Custody Order, I think is what it's called. It's like a long name. But anyway, you have to file a response. Just call it a response. You can find that online, but it's again a document you're probably going to want to do with your attorney. It really mostly involves checking the appropriate boxes on the response, and once completed, you need to file that and serve it on the other party. So that's super important. You have to file that response within 20 days of getting the objection to as well. So the deadlines in a relocation case are really important that you follow. I recommend that you calendar those if you're doing this on your own, and that you do not miss them, because it can be fatal, which means it can end your rights in the case. So super, super important. If you don't, the other side could get a default order without any notice to you. So you don't want to do that. Discovery. We can talk about the discovery process briefly. Discovery process in a relocation is often different than it would be in a divorce. It doesn't usually hinge as much on the financials like it would in a divorce. You might not be sending a bunch of financial discovery. You're probably asking really targeted questions if you're serving what are called interrogatories that your attorney will know how to do. Talking about the factors in the relocation and the basis, and trying to get information and lock the other party in on, if you're the one objecting, on why they're moving. Or if you're the one who is trying to move, you have the presumption, so you might not serve discovery. But if they're objecting, you might want to ask some questions about why and what their plans are. And that's something you can do in discovery. Another and requests for production are also a part of discovery. So usually we'll serve a request for answers, which are called interrogatories, and production of documents. I like to do a deposition in a relocation case if it's contested. So I really get to talk to the other party and ask them a bunch of questions and a conversation under oath that I can use against them later at trial. And that gives me more information to inform their position. Not every attorney is going to do that, but a lot of us do. And it's very helpful. More seasoned litigation attorneys do that. You also, during the discovery period, there might be evaluations that are done. If one party or the other seeks a guardian ad litem or a parenting evaluator to make a recommendation on the relocation, which is often necessary and helpful, there might also be evaluations that are recommended by those professionals. Or you might seek an evaluation if you're claiming one of the parties has a mental health issue that's, or a DV evaluation if that's a basis for your desire to relocate. So a lot of things to keep in mind there. Anything else at this point, Melissa, that you want me to answer?
I think your information is just so thorough. There's not very many questions today.
Good. Love it. Okay, good. So this is important. The next thing for you to think about is dispute resolution. In most counties, you're going to get a case schedule, or in most counties, there's going to be a requirement that you participate in dispute resolution. Now, if you already went through a divorce or a parenting action of some kind, even if you're unmarried, you probably already did this. And you might remember that mediation can be a long day. It can be painful. You might not love the mediator, no matter who it is. Everybody feels differently about this. Some people love the process, some people don't. It's typically not a process where you're all sitting around a table and chatting. Mediation, most of the time, is done in what's called a shuttle context, which I think is really good, and it usually gets results. You'll be in one room with your attorney, other party will be in the other room with their attorney. Neutral attorney mediator will shuttle back and forth between the two rooms. This can be done virtually these days. We used to do it in person at somebody's office in different rooms. Now we very much usually do it on Zoom, although the in-person thing is coming back into vogue a little bit. So anyway, it allows you to have privacy for negotiations in your room. Actually, in a relocation action too, I really like it because you can make offers that can't be held against you if you don't settle. So I represented a dad one time who was objecting to a relocation, and he was like, I really don't want to go to trial over this. If I can get most of the summer, most of the holidays, and I can get, the right to go down and visit the other party like as much as I want with notice, I'm going to do it. So we made like a really over the top offer that gave him time, but also gave the other parent the ability to move basically right away, and a lot of other things. And we made that knowing that if it wasn't accepted at mediation, they couldn't come back later and say, oh, at trial, well, so-and-so said he was willing to do this and now he's not. None of that can be used against you. Offers of compromise and settlement in the negotiation process at mediation are protected pursuant to Evidence Rule 408. So that means nobody can bring them up later. So it's a really good time to be creative and be in your room working with your attorney and thinking about what works for you to try to settle the case. And if you can't and it doesn't settle, it doesn't settle. But courts don't really want to make decisions about your parenting plan. That's something that in divorce and even in relocation, excuse me, courts don't want to make that decision. They want you to work it out. So that's the reason for the dispute resolution requirement. But in certain circumstances too, like the person that asked a question earlier, the other parent has a protection order and they don't see the child. Domestic violence protection order is a basis for waiving the requirement for alternative dispute resolution. So you're not going to be required to mediate in most circumstances if you have a protection order. Although now that we do virtual mediations, which we didn't used to do before COVID, really, a lot of the time, the reason for that was because you didn't want to have people in the same proximity, even if you don't see the other party. Now with Zoom, I have had a couple cases with protection orders over the last several years where the court's been like, you both have attorneys, this is via Zoom, try to work it out. I don't care that there's a protection order and they've ordered the parties to mediation anyway. But in a situation where there's like a 5-year order and the other parent's not involved at all, they're probably not objecting and you're probably not ending up getting ordered to mediation. And the presumption would be that you don't have to do it. So those are important things for you to know. I want to make sure I talk about the factors. So I'm going to talk about the factors because I think this is, somebody asked earlier, how do I build a strong case, right? Well, you got to know what the factors are. And there's 10 factors. I'll tell you what the 11th is first, because that only applies for a temporary order. The factor number 11, it's about that process I was talking about earlier. If you're trying to stop somebody from moving, or if you're trying to move temporarily, the amount of time before a final decision can be made at trial is an 11th factor. So like if you're doing that now and you, let's say, aren't going to have a trial on this for 4 or 5 months and the school year is starting before then, that'd be a factor that the court would consider on a temporary basis. Like, gosh, do I want the kids to get there in August or September, or do I want them to get there in like February? What, you know, so things like that become a factor on a temporary shortened schedule. But let's talk about the other factors, unless there's anything I need to touch on first, Melissa, that you think I'm missing or that you want to comment
Just
about.
one question. I think it's a good question that others might have as well. Does the court view coercive control as a legitimate reason for relocation?
I don't really ever make it through a webinar or meetup or anything else without someone talking about coercive control. First of all, let me say this. If you are, I don't mean to put down coercive control, so I don't want that to be the perception. But for anyone that doesn't know, first of all, if you're the victim of coercive control, I'm sorry, and it's terrible. It's horrible, honestly, to be on the other end of a person who has employed coercive control tactics. If you're listening and you're like, what the heck is coercive control? What's she talking about? So over a year ago now, Washington State expanded their definition of domestic violence to include coercive control. Coercive control is a pattern of behavior that interferes with the liberty of one party. It can be financial control, it can be verbal abuse that is coercive control. Determining what coercive control is and whether your situation applies is something you should discuss with an attorney because it can be taken a lot of different ways by a lot of different courts. I recently did obtain a coercive control protection order that I felt pretty good about because it was a really prime example of coercive control. My client really needed that protection. So I'm not saying that coercive control is a bad thing, but it always comes up now because it's a relatively new thing. And it is a form of domestic violence. And so is the court going to consider domestic violence? Yes. Yes, they are. The question for you is going to be whether there are restrictions in your current parenting plan under RCW 2609191 called 191 restrictions. If you have a parenting plan with restrictions, you've heard 191 restrictions. If you don't, and you might want to know about that. 191 restrictions can be for a variety of reasons. That is one of the factors I was going to mention. I think it's factor number 4. And if there are restrictions, they could be for coercive control. If there are no restrictions and coercive control is a new thing that wasn't happening when your parenting plan entered, are you getting a protection order? Because you could try to get one. If you got a protection order, that would be a factor that would be strongly weigh in heavily in favor of you relocating. So it's gonna be a question of what's the documentation of coercive control? Has it been a basis for restrictions? Should it be a basis for restrictions? Coercive control is domestic violence, but I will tell you, if you don't have a protection order or have a restriction on that basis in your current plan or a protection order, sometimes proving coercive control has been going on is difficult. One thing, and then I will move on from this, but it's really important, is the timing of your allegation of coercive control. Here's the thing. You enter a parenting plan. This happens a lot to people. So if it's happened to you, don't feel bad because it's a common thing. Let's say you entered a parenting plan and it was 5 years ago. And then you come to court and you're like, hey, I want to relocate now. And then you start talking about a pattern of abuse. Maybe it's coercive control, but let's just not even say that because that wasn't a thing 5 years ago. Let's say you're like, this person has a history of domestic violence. They've always had a history of DV. Or let's say this person is an alcoholic and it interferes with their parenting, and it always has. And you're making those claims, but you entered into a parenting plan 5 years ago that said these weren't problems. That's not great. So when you enter a parenting plan and maybe you just wanted to get it over with and you didn't reserve those restrictions for later, that can come back to kind of bite you. If you reserved restrictions and you're bringing it up now, it looks like, okay, hey, I tried to make this work, it didn't, so I'm raising the issue again. So that's really important. If you had a parenting plan that you settled a year or two ago and coercive control was an issue at that point under the statute and you didn't raise it and you're raising it now, court's going to be like, is this something that happened since the parenting plan entered? If so, yes. If you're saying it was happening before and now you're just bringing it up, then the court's going to be like, well, why didn't you bring it up before? And it kind of cuts against your credibility. So yes, coercive control can be a factor, especially if it's a basis for restrictions. Long answer to a very good question, but I couldn't get away today without talking about coercive control. Okay, anything else before I go through the factors?
There's one more question. I don't think this falls under the relocation example, but maybe we can explain what they would do. If you're looking to take a child outside of the country for a school sport, like for a week, and they're going with a big group and it's official, an official event. I'm assuming that's not relocation.
No.
So what
No,
would
no.
you do in order to get that?
That would be based on you'd want to look at what your parenting plan says about decision making, who's making decisions about extracurriculars, out of state travel, things like that. Good question though. Really good question. All right, I just want to hit on these. So the first, I'm going to read them all to you, and I'm not going to take a ton of time to talk about them, but the bottom line is, because we don't have a ton of time, but the bottom line is this. Each factor is going to be decided to weigh in favor of parent A or parent B, okay? So when you're talking about how to strengthen your case, you want to stack up a case that's going to support as many of these factors to go in your column as possible. That's what you want to do. And there are 10 of them. So the first one, the relative strength, nature, quality, extent of involvement, and stability of the child's relationship with each parent, siblings, and significant others in the child's life. So we call this one the relative strength and nature. So what's the relative strength and nature of the child's ties to you and your immediate family? Maybe you have a step parent involved, maybe there's other kids in the home, like half siblings or whatever. Like, what are the ties and the strength of those people here that are either staying here or that are moving? Strength and nature. The most thing that obviously step parents and other siblings and grandparents matter, but what's going to matter most is the strength and nature of the relationship between the parent and the child. That's what it is. The second one is prior agreements of the parties. This one's important, and I said I wasn't going to talk about these, but I'm going to give you a nugget on each one. So prior agreements of the parties. This is important. I had a parenting plan. It has happened a few times. And people will be like, hey, we wrote it in our parenting plan that we did ourselves that nobody would agree to relocate. Nobody cares. You can't waive the statutory requirement. Like I started out by saying, you can't edit it. You can't get around it. Even if you say, we agree that we're going to move later, I'm going to cause a freaking nightmare for you later. Trust me. I've had clients where they put things in their parenting plan that were never enforceable and it's created an issue. But prior agreements can be a thing. If you guys had an agreement in an email one time saying, hey, I'm going to move, and the other party was like, cool, once you get that job, you go for it. And now the person's rejecting, they're going to be like, oh, there was a prior agreement. That could weigh in favor of mom or dad. Most of the time there are no prior agreements, so it's usually neutral. These factors are, I shouldn't say mom or dad too, sometimes it's two moms, two dads. It doesn't really matter. It's parent A and parent B. So factors are going to be parent A or parent B, or they're going to be neutral, and that means they cancel out. If there are no prior agreements, an email, text, in your parenting plan, it's neutral. But my point here is agreements in your parenting plan that say no one will move or everyone will move are not binding. They're just a factor, or via text or email or our family wizard. So anyway, the third one is whether, this is really important. Gosh, this one kills me. Whether disrupting the contact between the child and the person seeking relocation would be more detrimental to the child than disrupting the contact between the child and the person objecting. So this is a really hard one for courts too. Like, what's more, who are you to weigh that? They have to, but they have to say, is it more detrimental to disrupt the contact between the person you're moving away from or the person you're moving with, which parent. It's a really hard one. The other thing too is, like I said, sometimes the factors can be neutral. I've had a court on this one say, well, gosh, the ties with both parents are really strong. We're going to just cancel that one out and say it's even. That can happen too. But you really have to say, is it more detrimental to disrupt the contract between parent A and B, or I'm sorry, parent B or parent A? It's a tough one. Number 4 is whether each parent or a person entitled to residential time is subject to limitations. This is the one I mentioned earlier, and it is factor 4. RCW 2609191 is where it enumerates the restrictions in sections 3A and 3B of your parenting plan. If you have restrictions against you or the other parent, you know, and that can be restriction on time, decision-making, any number of things that fall under that. And if there are restrictions in a parenting plan, that is a factor that will weigh against you if you're subject to restrictions. It'll go in the other person's column. If there's no restrictions, that's something that'll just be even and equal and canceled out. And that's very common. Not very many people have restrictions in their plan against the other parent. But if you do, that weighs in your favor if you're the one who has them against the other parent. And then number 5, this is important too. The reasons of each person for seeking or opposing the relocation and the good faith of it. I had a relocation not long ago, and mom wanted to move for work and to be near family, and because she was being offered a job offer. Dad was really mad that she wanted to move, and he had a lot of time with the kids and was super involved coaching sports, so he objected. So mom was in good faith for asking to go, and dad was in good faith for objecting. So that one canceled out. If one party, it looks like, is just trying to move because they want to disrupt contact, like I talked about earlier, if you don't support your position well, that one could end up weighing against you because it looked like it's in bad faith. So do you have a good faith reason for going? Do you have a good faith reason for objecting? That's that one. Number 6, this is the age and developmental appropriateness of the impact for the child. So I think the language is actually the age, developmental stage, and needs of the child, and the likely impact on the relocation or prevention it will have, the relocation will have. So like, if your child is really young and they're not really in school yet, but disrupting contact with the other parent is an issue, that could be an age and developmental thing. If your child is right in the middle of like junior high or high school and they are like really juiced into their friend group and their extracurricular activities, that would be something that would come under this factor. If your child has special needs and is in a special program at their school, is there a program that's like commensurate on the other end that they're going to? Like, what's going to happen there? So this is really about the age and developmental needs and whether the relocation is going to interfere with those things or strengthen them. Because sometimes it's better if someone's going somewhere where there's a ton of resources. So things like that are really important. Number 7, this one, I don't love this one. This is the quality of life, resources, and opportunity available to the parties where they are now and where they're relocating. And I'll tell you why I don't love it. Don't do this either. Sometimes you'll be in a relocation and someone will pull up a bunch of demographics and talk about how bad the Seattle schools are compared to where they want to move. Well, your judge probably has kids that went to Seattle schools, and this is the community we live in, and no one's going to care about your data on what your school district looks like online. I hate to say that, but this comes up a lot. Someone's like, oh my gosh, I want to move to this school. It's in a much better neighborhood, and it's way better than District A, and then they're stacking up data about the school districts. That's a minor factor. Usually the court will be like, opportunities are good in both places, but you want to be careful about how you present that, and you want to know your audience when you do it. And that's where it helps to have an attorney that, understands how to present that to a court and the judge that's going to be hearing you. Yeah.
I'm just where we're right at time. So I know we
I
have a
know.
little bit more. There is one.
I'm gonna rush through these. So I
Okay.
just got you through number 7. I'll give you the last couple. So anyway, quality of life and resources, depending on where you're moving away from Seattle can be really tough because we have a lot of great resources here. So you want to be careful about how you deal with that. Number 8. This is important too, the alternative availability of arrangements to give access to the other parent. Can the other parent afford to fly down there? Can you afford to fly the child back? How far away is it? Is it West Coast to East Coast? Or what does it look like? Like, what's the availability of arrangements to still continue contact? Number 9, alternatives to relocation and whether it is possible for the other party to relocate also. I had 2 parents working in Amazon that were divorced one time, and the argument was really like, hey, we're moving to area X and Amazon has a huge office there and they could probably move too. Or at the time they could work remote. So is it possible the other parent could move? And are there other arrangements? Do they have to move for work? And then finally, the financial impact on the logistics and relocation of its prevention. So that is your relocation summary. 10 factors, 11 if you consider the temporary plan. I've given you a lot of information. If you're thinking about relocating, talk to an attorney. Don't screw it up. And good luck to you. Thank you so much for coming today. I hope this was helpful. All of our webinars, by the way, are available online. You can go to our website and link to our YouTube channel there. I've done a lot of these over the years, so they're there if you want to rewatch them again, or if you didn't catch something I said. This one probably will be up in the next week or so. So anyway, thanks again for coming. Thanks to Melissa for asking the questions and being patient as always. I wish you a great day. Take care.
Thanks, everyone. Just going to put up a contact slide here real quick. Feel free to get in touch if you have more specific questions for Michelle or the Family Law Group. If you're in need of counseling services, please reach out to me directly. We appreciate everyone coming, and we'll be in another webinar coming up soon. Take good care.